Any mention?
May it please your Lordship. Lordship, I beg to make a mention of item number 9. This is a matter that's been part heard, Lordship. I'm praying if this matter may come up after a week's time.
How long?
A week's time, my lords.
2022 matter.
Lordships, it's a part heard matter.
Exactly, because it's part heard.
Lordships, after a week's.
1 week.
Obliged.
Highly obliged, Lordships. Lordships, a similar prayer for item 11. Item number 11, Lordships.
This is also
Your Lordship, I am appearing for respondent number 3 and 4 here on item 11.
11.
Yes, Your Lordship.
1 week.
Highly obliged, Lordships.
Deeply obliged, Your Lordship.
May it please your Lordship. Your Lordship, I beg to mention item number 18, hearing, Your Lordship. Beatrix Imyong versus KHEDC. I'm for the respondent number 1, 2, and 3, Your Lordship.
My lord, if it can be fixed after a week, very short matter, my lord.
Yes, Your Lordship.
Very short
after
matter.
a week.
I then she wants to seek some instruction.
I need to seek
Otherwise,
fresh.
it's very short matter, my lord. Without giving me show cause notice, I have been removed from as a CM, my lord. So only on that point only.
Instructions, Your Lordship.
After a week, my lord.
Yes, Your
1 week.
Oh,
Highly obliged, Lordship.
But I beg to make mention of item 5 and 6, my lord. It's not possible today. If it is taken up any other day, my lord. I have some difficulties. 5 and 6. 5 and 6.
And this also old, very old matter.
Yes, my lord. Next day I will try to finish it.
Two weeks.
2 weeks.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 14.
Yes, you're there.
It's not here, Your Lordship.
Your petitioner.
Yes, Your Lordship.
2 weeks.
Obliged, Your Lordship.
Lordship, I beg to make a mention of item number 19, Lordship. I am appearing on behalf of Miss Adatar, Lordship. Lordship, I am praying for some accommodation, Lordship, in this matter.
3 weeks.
May it please your Lordship, I beg to mention item number 20. Praying for 2 weeks' time, Your Lordship.
3 weeks.
Much obliged.
May it please your Lordship, I beg to mention item number 7. This is a joint 7 and 8 connected, Your Lordship. This is joint request. Praying the matter to be fixed after 2 weeks, Your Lordship.
Two weeks.
Your Lordship.
Please, Your Lordship, I beg to mention item number 13. Your Lordship, I pray for 2 weeks' time since the conducting council
This
is.
a small matter, Your Lordship. Can they fix it for short date, Lordship?
This matter has been heard.
No, Your Lordship.
This matter has not been heard. There was an amendment application that was filed that was allowed, Lordship. Thereafter, the matter has come for hearing.
Can you fix it for short date, Your Lordship?
2 weeks.
Much obliged.
From supplementary list, item number 1.
Same here. Judgment could not be prepared. We have that 3 months deadline. So I'll fix this matter for rehearing. Katuka order. 2 weeks.
Yes.
Item number 5.
May please Lordship, as per the last order, I was directed to file an affidavit to bring on record the service of notice of punishment number 3. In compliance to the last order, I filed my affidavit to bring on record the factum of service of respondent number 3.
Where is your? Who is this deponent?
He's the chief business manager of the national insurance company. Chief business manager
But
of the national insurance company.
yes, not. It is not clearly indicated as to his. You look at the affidavit. It is not clearly indicated as to his designation or what what his authority is in the organization. He just says that he is serving as a PSU employee. What is a PSU employee? Is he authorized? And where's the authority then? It has, it has to be very clear.
Okay.
Anyway, the affidavit will be allowed only for this time because the material is sufficient for this court to take out decision. Since the notice has refused to accept notice, that will go. But then this kind of affidavit should not be filed. It has to be very clear. Who is the deponent?
Okay.
What is his relation to the case?
Please.
He just say that he is authorized, and if he say authorized, then there must be accompanying authorization.
Okay.
Heard, Mr. Leonard, counsel for the. Is there an application for condonation of delay?
Yes, Lordship. 279 days.
Leonard, counsel for the applicant was submitted that the applicant has taken steps for issuance of notice on all the respondents. So this is only with regard to respondent number 3.
Yes, Lordship.
What about 1 and 2?
1 and 2.
I am for the 1.
1 and 2.
2 is the driver.
No, 2 is the owner.
2 is the owner of the.
Owner of the oil tanker.
He has received notice.
I have issued notice. Has been delivered.
Delivered?
Yes.
Nobody is appearing on his behalf.
Nobody did it. Not sure.
Have you filed an affidavit of service As far as 2 is concerned.
2 is concerned, yes, Lordship. No.
Yes. 1, 2.
If you can kindly come to the affidavit filed on the 18th of May.
See, same.
Uh,
You are appearing for 1, Mr. Padia?
Yes, Lordship. I am appearing for respondent number 1.
And?
Your Lordship, I'm appearing for respondent number 4.
4.
Yes.
5.
5, no one has appeared, Lordship.
No one has intended to open, Lordship.
Kurung toko. Next. However, only the respondent number 1 and number 4 respectively has entered appearance before this court. Respondent number 2, 3 and 5 have failed to appear before this court in spite of service being affected on them. It is prayed that this matter may proceed ex parte, this court may proceed ex parte against such respondents. This court has considered the submission made and has perused the record on in this regard. So, the appellant, the affidavit of service has clearly indicated that the set notice issued upon this set respondents have been affected. In fact, as far as respondent 3 is concerned, the notice has returned as refuse. I underquote my two, refuse. Yes. Under such circumstances, this matter will proceed ex parte against the said respondent number 2, 3 and 5 respectively. Where is your 279 days?
279 days, Lordship. 279.
Yes, Mr. Puri.
Your Lordship, as far as respondent number 1 is concerned, I will not have any objection.
Lordship,
Leave
I have to
entirely
seek
open the discretion of the
instructions.
Honorable Court.
I have to seek instructions since the conducting counsel is on leave.
This application can be heard on the next date, Lordship.
Yes.
I have a joke order. This case. As far as the hearing on merits of this application is concerned, that is the prayer for condonation of delay of 279 days or so in filing the related appeal. Mr. S.D. Opadia, Learned Counsel for the respondent number 1, has submitted at the bar that the respondent number 1 has no objection to the prayer made. Next, however, the counsel appearing for respondent 4 has sought time to seek instructions in this regard. In this instruction as to the response of the said respondent in this regard. So accordingly, let the let the response be filed before this court within the next date fixed, matter to be heard thereafter. This is matter up to 2 weeks.
Obliged.
Item number 4.
May it please your lordship. This is that matter of the civil suit which had been filed by the respondent number 1 in respect of a boundary dispute. Now, my lords, we had filed an application under Order 7 Rule 11 for rejection of the complaint on the ground that it was barred by limitation and it did not disclose any cause of action. Now, the trial court has passed an order which, in our understanding, is absolutely perverse and it is a non-reasoned order, my lords. And, my lords, instead of going, I would propose this, instead of going into the technicalities and the merits of it, I would argue today for a remand, my lords, and I'll show your lordships why this necessitates a remand. But the subject matter before the learned trial court was an application under Order 7 Rule 11, and the principal ground was the issue of limitation. Now, my lords, I'll take your lordships through the impugned judgment. The court has not discussed the starting point of limitation or the end point of limitation. The court has not discussed which article of the Limitation Act will apply to the proceedings. Nothing has been discussed, and the court has come to a perverse finding that the plaintiff has approached the court within time. Now, my lords, will please see the impugned judgment, and I will attack that judgment on perversity, my lords. That impugned judgment is at page 282 of my application.
Just a minute. This matter has not been heard earlier.
Partly. I had taken your lordship through the plaint in quite detail, specifying the categorical pleadings taken by the petitioner. My lords, this is the same property which is located behind Pine Mount School, where the plaintiff was alerted about a possible encroachment in the property sometime in 1988 to 1993. Thereafter, there was complete inaction on the part of the plaintiff for several years. So there's a vacuum over various periods over the last 30 years. Now they say for the last 27 years they've been litigating, and therefore they say the Limitation Act will not apply and they're entitled to the benefit of Section 14 of the Limitation Act. Now we are saying, assuming that is the case,
How long will it take, Mr. Sir?
It'll take a little bit of time. I'll have to be fair. Thereafter, my friend will have a detailed reply.
Do we have time? So, in the meantime, the rest of the board will be discharged. Yes, you're referring to?
My lord, TC page 282.
Okay. This is the impugned order.
Yes, my lord. This is the judgment dismissing my application under Order 7 Rule 11.
Yes.
My lord. Now, my lord, this is how I'll break down the judgment, my lord. This judgment consists of 18 pages in total. there are about 10 paragraphs. And once I'm being critical, maybe a little unfairly, because my lords will find as I take your lordships through the judgment, there is no reason assigned by the court. Now please see para 1 of the judgment, my lord. This reads, the incident case is put up for order on an application under Order 7 Rule 11 A and D read with 151 CPC, in which averments are as follows. And then the averments run. These are the averments reproducing my application under Order 7 Rule 11. This proceeds all the way till page 287. So this is a reproduction of the application up till page 287 at the bottom. Kindly see. At the bottom,
287.
my lords. So this ends with my prayer.
Okay.
So the court verbatim reproduces my application in verbatim. Then para 2, my lords, reads, on the other hand, the respondent defendant has filed show cause stating as follows. And then the respondent's show cause is reproduced. Now I will also submit, and I'll take your lordships in detail through this, that the respondent's show cause is not entirely consistent with the plaint. It is basically a show cause designed to fill up the lacuna in the plaint. As we pointed out, immediately upon pointing out that it is barred by limitation, there is a technical fault. They filed this show cause in answer to our Order 7 Rule 11 application, trying to fill up the lacuna and trying to explain things which are not otherwise pleaded in the main plaint. Now this goes on for a while, and then please see, my lords, as I just keep taking your lordships through the letter, entire reproduction of the show cause takes parawise comments and goes on till page 299. So from 283 to 299 is a reproduction of the plaintiff's pleadings. So from page 283 to page 299, it is just a reproduction of the application of the show cause. And the rest of the discussion and the holding of the judgment is in this last page, page 299 and 300. Now may I just read this, my lord? Para 3. The learned counsel for the petitioner defendants and the opposite party plaintiff were heard. The plaint and its annexures and the pleadings of both the parties in the incident case are perused. Now I'll just pause here for a moment, my lords. Now Order 7 Rule 11 is always confined to a reading of the plaint and the documents that are attached to it. There are several judgments of the Honorable Supreme Court on this particular enunciation. It says that the counters are only within the court must confine its investigation only to the plaint and the documents enclosed. It cannot look at a written statement, assuming there is a written statement or any documents or evidence. Only the plaint. And it has to read the plaint as is without any additions or any subtractions. Now, in para 4, what the court records is the plaint and its annexures and the pleadings of both the parties. Mana, pleadings by definition in CPC is the written statement and the plaint. There was no written statement, my lords. So here there is a perverse finding on the part of the court that there is some pleading on behalf of the defendant. I am the defendant before the learned trial court. Then it goes on to say, it is the contention of the opposite party plaintiff that the main relief sought in the plaint is that of possession with declaration and injunction being as consequential reliefs. The title to the suit property is undisputed and the relief for declaration is sought for the limited purpose of causing amendment to the opposite party's lease agreement to include the portion of the suit property encroached upon by the petitioner number 2, defendant number 1, and that for the purpose of limitation time has not begun to run. Please note this, my lord. They say for the purpose of limitation. Now this is his arguments before the learned trial court. In the plaint, and I've taken your lordship, if my lords recall, they say my suit is barred by limitation. Because the cause of action, the earliest cause of action arose sometime in 1988 to 1993. And after relaying all the facts, they say my suit is barred by limitation. However, because I was litigating at various forums, therefore I am entitled to the protection of section 14 of the Limitation Act, which basically says the courts will exclude such period where a person has bona fide taken up a case before a wrong forum. So they claim this is a wrong forum. For the last 27 years, we've been prosecuting this matter before a wrong forum. So we're entitled to the benefit of exclusion of that time. So they admit, number 1, that the case is barred by limitation. But para 5, what it reveals is their contention now, which is an alternate contention that the suit is not barred by limitation. So this is very important, my lords. So they say, and that for the purpose of limitation, time has not begun to run because the petitioner number 2, defendant number 1 has not raised any claim of adverse possession and is barred by law from raising such claim under Article 65 of the Limitation Act. Limitation period is only for a period of 12 years and not 3 years. This is their contention before the learned trial court. Oral submissions, not part of the original pleadings in the plaint. As I say, my lords, the court has to read the plaint as is without any addition or subtraction. Now then please see para 6. The annexure 8, so and so, so and so, so and so, and please see towards the end, to the plaint, indicate that the plaintiff has sought for survey of land for demarcation of boundaries, and there has been communication from the opposite party plaintiff regarding the encroachment of the petitioner defendant 1 upon the property of the plaintiff opposite party number 1. In a very short paragraph, the court condenses its entire inquiry of the vast writ petition and all the correspondences ranging from 1998 up till the time of filing of the suit in this particular paragraph, without really explaining what the finding of the court is. Then para 7 reads, annexure so and so, so and so, so and so, the same exercise, indicate that the concerned defendants have taken it upon themselves to look into the matter and also for resolving the issue raised by the opposite party plaintiff, but no decisive step was taken in that regard, which does not negate the contention of the opposite party plaintiff that the defendant number 3 had throughout acted on the basis that he did have jurisdiction on the case at the relevant paragraph of the show cause or plaint. Now this, my lords, I have read it. I have not understand what is sought to be articulated by the court. I'm not sure what this is trying to present. So therefore the meaning is something has not been able to be conveyed by the court. Then please see para 8. It is the assertion of the opposite party plaintiff that there has been encroachment upon the suit property by the plaintiff defendant for which, pursuant to clause 8 of annexure so and so, he has communicated to the concerned authorities via said annexures, the defendant number 3, DC, defendant number 4, additional DC, and defendant number 5, additional director of surveys, had taken steps and exercised jurisdiction under the Assam Land and Revenue Regulation, Meghalaya Land and Revenue Regulations for survey and demarcation of suit property pertaining to the encroachment and demarcation of proper boundary of the suit property, but could not reach a definitive finding on the subject matter, and instead order dated 10 June 2022 was passed without the plaintiff OP getting the remedy sought for. Now again, I am surprised because this was nobody's case before the learned trial court. I hope my friend will probably be able to assist this court to establish where this is borne out from. None of this is borne out from record. So I'm not really sure where this court again found this particular aspect. Now please see the interesting part, the finding of the court. In 2 paragraphs. Not a single judgment that has been relied upon by me or him.
Not a misadventure of cut paste.
My lord?
Not a misadventure of cut paste.
It's exactly that. That's the reason why I didn't want to go into all of that, my lords. So perhaps it's a very voluminous job for the court as well. And it's a little difficult to go into so many issues. My friend has put in a lot of labor, relied upon about say 10 judgments. I did the same. Now it's a very cumbersome process for the court to look at the facts of each case, to draw the ratio and apply it in this case. The court has to discuss the similarity of the cases, the question of law raised, question of limitation, what is the starting point, etc. It's not an easy job to decide limitation. But my lords, the holding of the court is only in this para 9, in one single paragraph, and this is what it reads. Having heard the learned counsels and after perusal of the plaint and its annexures and the pleadings of both the parties, there are no pleadings again. It is absolutely perverse on the part of the court to record this. In the instant case, this court is of the opinion that the plaint on the face of it discloses cause of action. That's all. And that the opposite party has been diligent in his pursuit for opening remedy for his grievances, for which rejection of the plaint at this stage, on the ground of no cause of action and bar of limitation, would not be justiciable in the given facts and circumstances of the case. In 7.5 lines, without discussing the law or the facts of the case, the court concludes that my application under Order 7 Rule 11 is not meritorious. And most importantly says that at this stage, for the intervening period, 711 cannot be decided or perhaps is not attracted. And the court records that he has exercised diligence in appearing before the court. That was never anybody's case, whether he's been diligent or not diligent. The question is a question of law. Is his case barred by limitation? And is he entitled to the benefit of Section 14 of the Limitation Act? My friend will also attest to the fact that he has made an alternative argument before the court that the period of limitation is not 12 years, it's actually 21 years or so, whatever the case may be. Sorry, it's not 3 years, it's 12 years. Nothing has been discussed by the court. Not a single article of the Limitation Act has been talked about or discussed. And my friend was also admit very fairly, none of the case laws that we had relied upon have been discussed by the learned trial court. So, my lords, the first issue is for your lordships to exercise jurisdiction under Order 227. What your lordships must first see is a reasoned order which suffers from some sort of infirmity or some sort of perversity or some jurisdictional defect. But where is that order? This is just a replication of the pleadings and the decision of the court in one short paragraph. Would that be enough for your lordships to even understand what was in the mind of the court or what the court was trying to convey? In my humble submission, this is not a judgment. This cannot stand scrutiny by this court because there is nothing to scrutinize in this judgment. This deserves to be sent back for a fresh hearing. Now, my lords, I'll rely on very few judgments. Yes. The first judgment is 2007 Volume 5 SEC, page 614.
Supplementary cost less.
Indeed.
That's a so many chocopores. 2007.
2007 Volume 5 SEC 614. The relevant page, my lords, is at page 626. Para 25.
Sorry.
Well, para 25, my lord. May I read?
Yes.
The language of Order 7 Rule 11 CPC is quite clear and unambiguous. The plaint can be rejected on the ground of limitation only where the suit appears from the statement in the plaint to be barred by any law. Mr. Nariman did not dispute that law within the meaning of Clause D of Order 7 Rule 11 must include the law of limitation as well. It is well settled that whether a plaint discloses a cause of action is essentially a question of fact, but whether it does or does not must be found out from the reading of the plaint itself. From the said purpose, the averments made in the plaint in their entirety must be held to be correct. Please note this, my lord. Must be held to be correct. The test is whether the averments made in the plaint, if taken to be correct in their entirety, a decree would be passed. The averments made in the plaint as a whole have to be seen to find out whether Clause D of Rule 11 of Order 7 is applicable. It is not permissible to cull out a sentence or a passage and to read it out of context in isolation. Although it is the substance and not merely the form that has to be looked into, the pleadings has to be construed as it stands without addition or subtraction of words or change of its apparent grammatical sense. So these are the counters of the jurisdiction of the court while hearing an application under Order 7 Rule 11. The reason why I'm putting this in service is because the court has recorded the statements made in the show cause which was filed by the plaintiff against my application Order 7 Rule 11. And as I was saying, that is materially different and a supplementary set of pleadings to their original plaint. And they're not very consistent. In the plaint, they say that the suit is barred by limitation. In the response, in the show cause, they take a different approach. So therefore, the court should not have looked into that and should have confined its investigation only to the plaint as it stood without any addition or subtraction. But then again, my lords, we don't have the benefit of really finding out what the court wanted to say because there is nothing on record. The next judgment, my lord, is the requirement of Order 14 of the Limitation Act. This is 2019, 15 SEC. That's 2019. volume 15 SEC, page 70. It's relevant pages, page 103, para 21.4.1.
21.4.1.
This reads, we may usefully refer to the relevant decisions pointing out the basic requirements for applicability of Section 14 of the Limitation Act. In so and so, this court pointed out the requirements on the plaintiff for the purpose of Section 14 in the following. In order to bring this case within the section quoted above, the plaintiff has to show affirmatively, 1, that he has been prosecuting with due diligence the previous suit in the court of the Munsif at Miraj, 2, that the previous suit was founded upon the same cause of action, 3, that it had been prosecuted in good faith, and 4, that the court was unable to entertain the suit on account of defect of jurisdiction or other cause of a like nature. Again, the reason for drawing support of this judgment is that they have admitted that the suit is barred by limitation and that they are entitled to the benefit of Section 14. There is no discussion by the court. Section 14 is not a matter that you look at dates and come to a conclusion. Court has to record its subjective satisfaction with regard to the existence of all 4 criterias. My lords will find, I've taken your lordship's judgment, there is no discussion on Section 14, much less the discussion on any of these criterias. My lords, the next judgment, my lord, is on what should be the ingredients of a judgment. 2023, volume 7, SCC, page 282.
282.
282. 2023, volume 7, SCC, 282. Is there an extra copy there? Relevant paragraph, my lord, it's para 12 onwards. I'll refer to a couple of paragraphs.
Yes.
May I first start with page 287, my lord. Para 9.
Yes.
Please see placitum G at the bottom. It begins with a judgment must make sense. Let's have it.
Yes. Yes, yes, yes.
A judgment must make sense to those whose lives and affairs are affected by the outcome of the case, while a judgment is read by those as well who have training in the law. They do not represent the entire universe of discourse. Confidence in the judicial process is predicated on the trust which its written word generates. If the meaning of the written word is lost in language, the ability of the adjudicator to retain the trust of the reader is severely eroded. We are constrained to remit the proceedings back to the High Court for consideration afresh. The judgment of the High Court is simply incomprehensible, leaving this court with no option than to remand the proceedings. The High Court must appreciate the delay and expense occasioned as a consequence and must make an effort to record reasons which are understood by all stakeholders. Then please see para 12. In so and so, as well, a 2-judge bench of this court was faced with an order of the High Court of Judicature at Allahabad which made it difficult to discern between the submissions of the counsel and the reason of the court. Laying emphasis on the purpose of a judgment, this court elaborated on what should be the context of a judgment. The court observed that judgment means a judicial opinion which tells the story of the case, what the case is about, how the court is resolving the case and why. Judgment is defined as any decision given by a court on a question or questions or issue between the parties to a proceeding properly before court. It is also defined as the decision or sentence of a court in a legal proceeding along with the reasoning of a judge which leads him to his decision. The term judgment is loosely used as judicial opinion or decision. Lord Atkinson of the Supreme Court of Queensland in her speech once stated that there are 4 purposes for any judgment that is written: to spell out the judge's own thoughts, to explain your decision to the parties, to communicate the reasons for the decision to the public, and to provide reasons for appeal court to consider. This is very important, my lords. What are the reasons for your lordship to consider? That's exactly what is absent from this impugned judgment. It is not adequate that a decision is accurate, it must also be reasonable, logical, and easily comprehensible. What the court says and how it says it is equally important as what the court decides. Every judgment contains 4 basic elements, and they are statement of material relevant facts, legal issues or questions. Our judgment suffers from the absence of this. Deliberation to reach at a decision. Again, this is also absent. The ratio or conclusive decision. A judgment should be coherent, systematic, and logically organized. It should enable the reader to trace the fact to a logical conclusion on the basis of legal principles. It is pertinent to examine the important elements in a judgment in order to fully understand the art of reading a judgment. In the Path of Law by so-and-so has stressed the insentient factors that persuade a judge. A judgment has to formulate findings of fact. It has to decide what the relevant principles of law are, and it has to apply those legal principles to the facts. The important elements of a judgment are caption, case number, citation. Now these are important, my lord. Facts, issues, summary of arguments by both the parties. And my lords, I must say, there is no summary of my argument. As we'll see again that that last page, there is no summary of what my contentions were or what I had argued or what the cases were that I had placed before the court. So issues, summary of arguments by both the parties, application of law, again very important, completely missing in the impugned judgment. And lastly, final conclusive verdict. Then please see the last paragraph. The judgment replicates the individuality of a judge, and therefore it is indispensable that it should be written with care and caution. The reasoning in the judgment should be intelligible and logical. Clarity and precision should be the goal. All conclusions should be supported by reasons duly recorded. The findings and directions should be precise and specific. Writing judgment is an art, though it involves skillful application. I'll just skip this minute. Please see at somewhere around the placitum F, it begins with therefore whenever a judgment is written. Therefore, whenever a judgment is written, it should have clarity on facts, on submissions made by the behalf of the rival parties, discussion on law points. Again, my lord, completely absent. And thereafter, reasoning, and thereafter the ultimate conclusion and the findings, and thereafter the operative portion of the order. There must be a clarity on the final relief granted. A party to the litigation must know what actually he has got by way of final relief. The aforesaid aspects are to be borne in mind while writing the judgment, which would reduce the burden of the appellate court too. We have come across many judgments which lack clarity on facts, reasonings, and the findings, and many a times it is very difficult to appreciate what the learned judge wants to convey through the judgment, and because of that, matters are required to be remanded for fresh consideration. Therefore, it is desirable that the judgment should have a clarity both on facts and law. Please note this, my lord. And on submissions, findings, and reasonings, and the ultimate relief granted. So, on a reading of this judgment, I would satisfy my lords that I would argue that the impugned judgment lacks everything that is sought to be proposed by this particular judgment. Please, the last judgment, my lord, is 2010 Volume 4 SCC 785.
2010?
2010 Volume 4 SCC 785. And the relevant paragraph is para 10 onwards, my lord, page 790.
Yes.
Again, my lord, this is also on the issue of what is to be provided, what are the ingredients or constituents of a judgment.
Yes.
That's para 10 minutes. The increasing institution of cases in all courts in India and its resultant burden upon the courts have invited attention of all courts in the justice administration system. Despite heavy quantum of cases in courts, in our view, it would neither be permissible nor possible to state as a principle of law that while exercising power of judicial review on administrative action, and more particularly judgment of courts in appeal before the High Court, providing of reasons can never be dispensed with. The doctrine of audi ultram partem has 3 basic essentials. Firstly, a person against whom an order is required to be passed or whose rights are likely to be affected adversely must be granted an opportunity of being heard. Secondly, the authority concerned should provide a fair and transparent procedure. And lastly, the authority concerned must apply its mind and dispose of the matter by a reasoned or speaking order. This has been uniformly applied by courts in India and abroad. And please see para 13. At the cost of repetition, we may notice that this court has consistently taken the view that recording of reasons is an essential feature of dispensation of justice. A litigant who approaches the court with any grievance in accordance with law is entitled to know the reasons for grant of rejection of his prayer. Reasons are the soul of the orders. Non-recording of reasons would lead to dual infirmities. Firstly, it may para 13, my lord.
Okay. Yes.
I'll just read it again.
Please, no. Just continue.
Yes. Non-recording of reasons would lead to dual infirmities. Firstly, it may cause prejudice to the affected party, and secondly, more particularly, hamper the proper administration of justice. These principles are not only applicable to administration or executive actions, but they apply with equal force and in fact with a greater degree of precision to judicial pronouncements. A judgment without reasons causes prejudice to the person against whom it is pronounced, as the litigant is unable to know the ground which weighed with the court in rejecting his claim, and also causes impediments in his taking adequate and appropriate grounds before the higher court in the event of challenge to that judgment. That's exactly my case, my lord. I don't know on what ground the court has dismissed my application. I have satisfactorily argued why section 14 will not apply and why the suit is on the face of it, ex facie barred. The court has not given me an opportunity to understand what was wrong with my argument. That's why the judgment is not a transparent judgment in that sense. Now, we may refer to certain judgments of this court as well as the high courts which have taken this view. The principle of natural justice has two ingredients. Firstly, the person who is likely to be adversely affected by the actions of the authorities should be given notice to show cause thereof and granted an opportunity of hearing. And secondly, the order so passed by the authorities should give reasons for arriving at any conclusion showing proper application of mind. Violation of either of them, this is very crucial, my lords, violation of either of them could, in the given facts and circumstances of the case, vitiate the order itself. Such rule being applicable to the administrative authorities certainly requires that the judgment of the court should meet this requirement to higher degree of satisfaction. Absolutely absent in this particular case. The order of the administrative authority may not provide reasons like a judgment, but the order must be supported by reasons of rationality. Let's please see para 14 at the bottom. I'm sorry, para 16. In McDermott International versus Byrne Standard, the Supreme Court clarified the rationality behind providing of reasons and stated the principle as follows. Reason is a ground or motive for a belief or a course of action, a statement in justification or explanation of belief or action. It is in this sense that the award must state reasons for the amount awarded. The rationale of the requirement of reasons is that reasons assure that the arbitrator had not acted capriciously. Reasons reveal the grounds on which the arbitrator reached the conclusion which adversely affects the interest of a party. Such reasons shall not only be intelligible but shall be reasons connected with the case which the court can see is proper. Contradictory reasons are equal to lack of reasons. Then, my lords, lastly, para 18, my lords. Sorry, para 19.
Yes.
The third last line, my lord. The orders of the court must reflect what weighed with the court in granting or declining the relief claimed by the applicant. And this is also very important. Then, my lord, will turn to page 797. At page 797, this is an extract of some other judgment. Please see that extract from para 19 onwards.
This starts from which para?
My lord, I'll just tell you. This starts from para 20.
Okay.
They are referring to the judgment of Pipe Arts India from the Bombay High Court at para 20. The reference is at para 20.
Pipe Arts.
A bench of the Bombay High Court in Pipe Arts India.
Okay.
May I read, Manoj? The court cannot lose sight of the fact that a losing litigant has a cause to plead and a right to challenge the order if it is adverse to him. Opinion of the court alone can explain the cause which led to passing of the final order. Whether an argument was rejected, validly or otherwise, reasoning of the order alone can show. To evaluate the submissions is obligation of the court, and to know the reasons for rejection of its contention is a legitimate expectation on the part of the litigant. Now in this case, we have raised various claims before the court, various contentions. Now we don't even know, we know that it's rejected. The whole substance of the entire application was rejected, but we don't know the reasons why they were rejected. No legal points were formulated. Then please see the next paragraph. When reasons are announced and can be weighed, the public can have assurance that the correct process is working. Announcing reasons can also provide public understanding of how the numerous decisions of the system are integrated. In a busy court, the reasons are essential demonstration that the court did in fact fix its mind on the case at hand. An unreasoned decision has very little claim to acceptance by the defeated party and is difficult or impossible to accept as an act of reflecting systematic application of legal principles. Then may I just request your lordships to come to page 801. Yes. Although this was an application, this was not a case where the court was deciding on pleadings and there was no need to formulate issues under Order 14. But even in miscellaneous applications, there's a general practice by courts. When there is a serious question of law involved, the court usually formulates a question of law. And please see this, page 801, this is a continuation of para 26 from the third line onwards.
Okay. Yes.
In fact, Order 14 Rule 2 read with Order 20 Rule 1 of the CPC requires that the court should record findings on each issue, and such findings would obviously should be reasoned, would form part of the judgment, which in turn would be the basis for writing a decree of the court. Then please see para 27 Placitum C. It begins with a reasoned judgment is primarily written.
Yes.
A reasoned judgment is primarily written to clarify own thoughts, communicate the reasons for the decision to the concerned, and to provide and ensure that such reasons can be appropriately considered by the appellate higher court. Absence of reasons would lead to frustrate the very object stated here and above. The order in the present case is as cryptic as it was in so-and-so case, being a cryptic order, and for the reasons recorded in that case by this court, which we also adopt, the impugned order in the present appeal should meet the same fate. So coming back to the impugned judgment, may I just again, for my own satisfaction, take your lordships back to page 299. Now, in light of the law and the principles laid down by the Honorable Supreme Court in these judgments, as we'll see, of the 18 pages, the only page that is relevant from where your lordships would understand if the court has exercised its jurisdiction properly is page 299 and page 300. It's just 1.5 pages of judgments. Where is the reasoning of the court in one paragraph in 7.5 lines? Have your lordships been able to understand what was in the mind of the court? Was there any formulation of a question of law? Was there any discussion on the points of law that were contended by either of the parties? All of this is missing in this judgment. Therefore, it is a fit case for a remand without anything further. There's no need to go into the merits of the case, because then your lordships will be acting in original jurisdiction. That is again prohibited under Order 227. Under Article 227. Your lordships cannot usurp original jurisdiction of the court. Courts have to perform their functions diligently and properly in a judicious manner. If that is missing and your lordships have to do the job of the trial court, it would amount to usurping the original jurisdiction. So I would submit, my lords, respectfully, kindly set aside the impugned judgment and remand it back to the learned trial court for a fresh hearing on this matter, keeping in light of the judgments of the Honorable Supreme Court and after looking at all necessary legal aspects.
Done.
Lordship.
We will continue. Next date. Please. Mr. SN, Direct GA for this petitioner's state. Place this matter for further hearing after 2 weeks.
Obliged.
Second call from supplementary list, item number 2.